Welcome everybody to the second day. We had a hugely successful, very pleasant day yesterday, welcoming back some old friends and seeing some existing colleagues, former colleagues. We had a good attendance online and face-to-face, which was nice, and it was very nice for me to receive all those plaudits from various people congratulating me and, of course, the whole school on the 25th anniversary. Talking of old friends, we have Professor Michael Adams. I remember teaching Michael in 1981 to 84. And then we lost contact for a little while, but we soon got back in touch. He moved to Australia. He's become a leading light in corporate governance and corporate law. And he's become a very good friend of the Coventry Law School and of the university. He's a visiting professor in the business school. And he's going to talk today about the benefit of global research and comparative research. Michael has got a wealth of research under his belt and as I say, has become a leading light in corporate governance, and his take an angle on corporate governance. And it's had a massive impact, and of course that's the main advantage of research, that it's going to have a great impact. So over to you, Michael, and thank you for joining us from Australia.
Thank you, Steve. Really appreciate it, and Stuart for inviting me to be part of the conference. And obviously to your head of the Coventry Law School, Gary Betts, and your Dean of your Faculty Business and Law, Jenny Ward. Some slides are about to pop up on the screen, and I'm grateful for Stuart showing off these slides. So thank you very much indeed for that great opportunity. So good morning, everyone. Now, obviously in Australia, we're the other side of the world. So it's actually just gone 6 p.m. in the evening here, which is a contrast of things, but I'm sure I can focus on the morning stuff. My paper is referred to as The Value of Comparative Legal Scholarship. And yes, I am Professor of Corporate Law and Governance, but also Academic Dean here at the Law School. Stuart, would you go to the next slide, please? In Australia, when we do any sort of public speech, it's now standard to do an acknowledgement of country to recognise we have a culture that is 60,000 years old, one of the oldest living cultures, and we acknowledge our traditional owners. So I'm on what is called Anawan people's land. So they're the local, there are about 300 peoples in Australia, all with their own languages and cultures and histories. And so this slide is a standard university slide to recognise our lands that we have campuses on. We have a few different campuses, and to give that acknowledgement, which is an important part of our history. It's certainly an interesting development. Next slide, please. So this is a quick little intro to what I thought I would cover in the 45 minutes or so that I have. I thought I'd start off with a little bit of reflections on my LLB honours thesis back in the day in 1984, which I obviously liked alliterations even then. The power to punish pupils was on a European court decision at a time where European law really was only for the UK, was only in its infancy. In this particular case, which I'll quickly mention, sort of sparked my interest in that comparative aspect. And then over time, as Steve has very generously said, we made a connection. I was at then the University of Technology, Sydney, one of the world's leading modern universities. Modern university, by the Times Higher Education, is under 50 years old and is actually now ranked at 47 and has been an amazing success story for a university. And I wrote some papers at that point. And then when I became Dean of the Western Sydney University, Sydney has 6 law schools for a city of 3 million people. And I continued writing some co-authored works, but all of them comparative. Then in 2017, I had the pleasure of coming back to Coventry and presenting to the law school and the business school in areas of corporate governance. And that led to an invitation to be a visiting professor for the next 3 years, which of course I've enjoyed, although COVID has delayed some of those plans, as you would expect. Then the majority of my time will be on some substantive comments around what I perceive to be the benefits of comparative law and why I think it adds to the value of scholarship for students, but also for academics and, of course, readers of the journal. Now, I must say that my comparison aspect or comparative aspect is mostly around different legal systems. But of course, that comparison can also be interdisciplinary. So I have done certainly work with colleagues in finance and economics, and also now here at a leading agricultural university in agricultural science. In fact, we have Australia's leading ag law centre. So all the regulations, everything from eating insects as food, usually for animals, not humans, through to water governance, because the pressure value of water and other parts of sensors even, and other bits of information around that. All of that incredibly important. If I may, let's go to the next slide. Which deals with my honours thesis. I had really good fun. My personal tutor was Dr. Broby, and he also was my supervisor. Now, I was dating a young lady from my area in the south of England who was doing teacher training at Bristol University at the time, and she felt she had the right to hit a child. I mean, it does in 2021 seem so alien, doesn't it? Does it not? But it got my mind thinking about the issues of corporal punishment. And although my interest, even that last year of studies, was much more commercial, I was drawn. I should also make acknowledge my wife is actually online watching as well, and she's heard this story before. But I decided to write my thesis on a European case that had just been decided, Campbell and Cousins, a leading authority, and I've given some citations there, a Scottish teacher who believed they had the right to hit a child through corporal punishment and took it through to the European Court. And of course, that was the landmark decision, which basically said that the teachers are not in loco parentis. They don't have the same rights as a parent to discipline. And in fact, the research, even in 1980s, showed that it was a very ineffective method of controlling a classroom and discipline. And there have been so many cases where teachers had been, particularly head teachers, had been frustrated, and the canings were much more around their own frustrations than actual any other reason at all. Anyway, that case brought an end to, over a period of time, the UK and obviously all European members changed their laws. But it was a good topic to write, and to put it in context, which probably gives Steve and I our ages away, of course, it was done on a typewriter. There was no computers. You could do no cutting and pasting, no Google searches, all of it done in a much more manual and slow fashion way. But it was certainly, and I still have a copy of that thesis. Let's move to the next point. Just as a side note, I also did do intellectual property as my elective in my law degree. And I must admit, I did fall in love with a Privy Council decision called Cadbury-Schweppes against pub squash. And then I think it's the only law report at that time that I read that actually had a colour photograph of a can of a soft lemonade drink called Pub Squash that looked very similar to Cadbury-Schweppes' version called Solo. Both these products, by the way, still exist. And when I very first came to Australia in 1986, I actually went and bought a can of Pub Squash and a can of Solo and took a photograph of them and then drank both of them to see what they look like. So that law report, but that idea of comparisons and connections, I think started to launch into my head. If you're interested, the law report there is 1980 UK Privy Council, case number 30. Then, as I said, as my academic life took off, Steve and I reconnected, and I have had the pleasure to publish 7 separate articles. But what you'll see, even back in 1998, my first article for the Coventry Law Journal was corporate law developments in Australia and the UK. So that comparison piece started to kick in quite early. Then my company law colleague at UTS, University of Technology Sydney, he and I wrote this piece in 1999, Recent Developments in Australasian Law. So we sort of looked at New Zealand and some of the other island nations in this region. Then a third company law lecturer at UTS, Chris Clark, Michael Whitehead, by the way, both of them now retired. We followed up with further recent developments, and that sort of followed again into the next. It was actually if Steve remembers, a big article. We cut it in two to spread over 2 copies because it would have been too long otherwise. Then in 2001, I went back to being a sole author and did the latest developments in Australian corporate law. And then the more 2 recent ones in 2017 and 2018 have, I guess, more of an interesting history in the sense I started to do a lot of work not just in the corporate law aspects of corporate governance, but I guess the more corporate social responsibility, and particularly the area of board diversity. Australia has been very slow to increase the number of females on boards, and as well as other types of diversity. It is increasing. It is, in fact, the latest results are in the region of 35% on a gender basis. There's still a long way to go to get to parity, but I also looked at Australia, India, and Asia to see what was happening. But the diversity also included people's educational backgrounds, their professional backgrounds, as well as their cultural backgrounds, to look beyond gender. Of course, there has been a lot of literature in the UK, in Europe, and also in the US on the gender issue. And obviously, being a male, I felt I could add more value on other diversity issues. And that led to a series of articles. The most recent article I published in the journal was with actually my PhD student, Musad Kardel, and that was he was from Iran on a government scholarship on part of his thesis, and so we did that sort of comparison. Of course, Coventry has some particular expertise in that area, and I was grateful that the Coventry Law Journal accepted an opportunity. Dr. Kardel has actually returned to Iran and is an academic in one of their universities. And I have some articles for the future if Steve, you're still, and Stuart's still interested in articles from Australia. I'm writing at the moment particularly on technology in the law and something called DAOs, which is decentralized autonomous organizations, which is the basis of Bitcoin and blockchain technology, but turned into securities for companies. And it's going to have quite a global impact. And the state of Wyoming in the US has just passed brand new laws to make these effectively limited companies. And these tokens are equivalent of shares. That's, I hope, will be something of interest for the UK. Let's get on to the next slide, and you'll see that, as I said, I've been a visiting professor over the last 3 years, and I have presented both in 1998 and in 2017, both on the area of basic comparative corporate governance on a global scale. And particularly my interest from what I call local governance, the way a local jurisdiction does things, and then as you become a global entity, how do those rules change? How do you engage laws and regulations and have principles? And I provided some great examples over that time. Let us then move to the next slide, where we can start to look at the clearer rationale to why I and many others really value comparative law scholarship. What are the things that really benefit? Now, I want to stress once again, this is about law scholarship. Of course, that could include other disciplines, that is comparing, said, with economics and finance type law, or with technology and various laws. But I'm going to really focus around on the jurisdictional aspect. I believe the common law jurisdictions, which is about a third of the world, have a great deal of similarities, but they also have very important distinctions and differences. And that's what makes it worthy of comparison. The UK in company law, is very famous for its Companies Act's been adopted in Singapore, in Hong Kong, in Malaysia, in India, and originally in Australia and New Zealand and in Canada. And then those countries that start with very similar principles then deviate and change based on local jurisprudence and local conditions. And then it's then interesting to see those influences change over time. So to do those comparisons, when I look through the Australian corporations legislation, it's fascinating to go back to the earlier provisions, and you can see the very close strings, those close connections to the original UK case law, and then, of course, particularly the legislative developments. So even by the end of my law degree, when I was doing my honours thesis and studying intellectual property, I started to see the importance of comparison on comparative law. But I'd also add, I think I started to also see the influence, the heavy influence of European law starting to come into the UK. When I later did my postgraduate studies at University College London, that became even more obvious in that particular law school, and its impact and significance within the courts became apparent. From an Australian perspective, our final Court of Appeal, called the High Court of Australia, actually has had a long-running history to be connected to the UK and citing House of Lords, now of course UK Supreme Court, and previously the connections through the Privy Council, which I mentioned as part of that Cadbury Schweppes and pub squash case. The US Supreme Court gets cited in a number of areas, but also other superior courts, particularly from South Africa, Canada, New Zealand, do get cited, as does, I know, Australian High Court cases back into those other equivalent jurisdictions. And in fact, you may be interested to know, on the 9th of September 2021, so just a few weeks ago, Australia made a very important decision relating to Facebook and publishers. Basically, some mainstream media put up some Facebook pages talking about a gentleman called Dylan Voller. He had been a detainee, a youth detainee in the Northern Territory, and a whole bunch of hate comments were made on the comment sections of Facebook of these major media companies. Mr. Voller brought a case against these entities for defamation. And of course, they said, we have no control over the comments that people make on Facebook. And in fact, the High Court of Australia has actually declared that the use of Facebook in this way makes the media companies a publisher, which of course imposes legal rights. The High Court has actually determined that it will be sent back to the Supreme Court, which is the first court of first instance, to determine whether defamation, and they may have other defences. But it's interesting that jurisdictionally, the Voller case has been very significant, and it followed on another case called Gutnick, which was also about defamation and where legal action should be brought when it's on a computer server. If we go to the next slide, you actually see a world map by jurisdiction, and you will see the brownish reddish colour are the common law countries, which represent about a third of the world. Of course, all the blue countries are the civil code countries, and of course dominated by China and Russia, and of course a great deal of Europe and South America. Then the yellow amber are the Islamic or Sharia law countries. And then I think the brown, the dark brown down in South Africa, or Southern Africa to be more accurate, where of course there was Dutch law, there's been British law, and there have been other countries' laws. So they have a true mixture. You can also see that, of course, up in Canada as well with the French influences. It's a good graphic to remind the influence of the common law system, particularly, but there are other jurisdictions that we should take into account. If we move to the next slide, we start to see some of the other comparative scholarship aspects and why I think this area of scholarship and academic writing has increased. First and foremost, the ability of technology, the invention of the internet, the World Wide Web, and communications. It's interesting that, as I think I mentioned on screen, watching is one of my best friends who was at Coventry as well, who did engineering, Julian Wainwright. Julian and I were the first outside of the university sector to share an email address. He worked for a technology company, a satellite company, and had an email address, and I obviously at a university, and we're talking the early 1990s. But as time has gone by, the ability to reach out to other academics, to look at websites of corporations or government sites or wherever it has been, has made it much easier to share scholarship. And I know that the Coventry Law Journal is in Scopus, so globally anybody can search and check and find the articles, find the back issues. Citations are much easier. You can look at Google Scholar or any one of those other indexing mechanisms to be able to find work. And so to actually do a literature review now is very different to what it used to be. And in practicing law, of course, many people used to only look at the most leading cases, the major authorities. Now, of course, it is possible to do a search across. In Australia, of course, we have states and a federal jurisdiction, and you could find 500 authorities on a particular point. And in fact, working through and making sure you apply the doctrine of precedent appropriately. So in our case, working through the High Court, the Court of Appeal, the Supreme Court, and then some of the other minor courts, it gives you a lot of case law very quickly, and you have to be more determined and distinguishing to select the right cases or the right legislation in the right way. But I think technology in its form has made such a difference. And this is, of course, before we start talking about the power of machine learning and artificial intelligence, which enables to refine those searches to look for even key words in huge judgments or theses or whatever it may be. Another aspect, which I guess leads on from the technology, has been the impact of free legal databases. Now, in the UK, you'll be well aware of Bailey. What you may not know is that Bailey originated out of Australia and is known as AustLII, the Australasian Legal Information Institute, and part of, with the US, a Legal Information Institute concept. And in fact, AustLII, and this is a fun fact, if you ever wondered how neutral citations came about, that is how we use square brackets, year, then the court's jurisdiction, and then the case number, and then paragraphs, that actually all came out of AustLII, that went around to these various common law jurisdictions and actually said, we cannot use page numbering, we need a systematic, simple approach, and their methodology was adopted by all the different jurisdictions. Convincing, by the way, the House of Lords to adopt it, I know, was an uphill battle. AustLII, by the way, was an initiative of UTS and the University of New South Wales, and said all these different jurisdictions. The one that I probably would recommend is WorldLII, because that brings together virtually every major jurisdiction that has free legal information all in one place, including academic scholarship, as well as obviously primary materials of case law and legislation. You also find some really good databases. So in fact, Royal Commission reports and that type of secondary material, but very valuable, is also available for free. Many, of course, are now on government websites as well. And nowadays, case law and legislation tends to be published very quickly onto government sites. The benefits of a database like WorldLII or Bailey or AustLII is, of course, they are beautifully indexed. So when you're searching, you get all the cross-referencing. So in a case, if there's a section cited, there's usually a hyperlink taking you immediately to that exact section. And usually you can look at the history, you can look at what is in power right now and what was previously the earlier versions. Of course, most libraries carry big subscription-based databases such as LexisNexis, Thomson's Reuters, Westlaw, and on it goes. And our libraries, pardon me, our libraries pay a lot of money for those provisions. But they also provide other services and have tremendous sophistication. And again, they make it easy through particularly the LexisNexis databases that you can check out what are the UK laws, what are the equivalent EU laws, what are the equivalent Canadian laws, US laws, and on it goes with that comparative basis. So that makes it pretty valuable. The next slide, please. So not only can we access the primary materials online from pretty well anywhere in the world, and of course during COVID and lockdowns we've all been working from home. As you can see, I'm back in my office today. I'm doing about 3 days on campus and 2 days from home, but through the major lockdowns I was at home, as pretty well everybody else was. You could continue to teach online and to research online, and the databases for academic articles have just exploded. And of course, as we certainly have a global movement for free access, most research grants now require you to publish in journals which are online and publicly available. Although, of course, we still will write for the major commercial journals, which, of course, they take the profits from those journals and the academics tend to write them for free. That somehow doesn't make sense, but that's the model we've had. and we appear to continue to do so. So the research databases are incredibly valuable, but also the primary sources, both hand in hand. One of the other aspects I've experienced, I'm sure others that have done comparative legal scholarship, of course, is the power of language. That is, we may use the same terms in one jurisdiction, but actually it could mean something quite different in a different jurisdiction. I'm just going to provide two simple examples of this where, and both have actually, one driven through one of my PhD students and one through a presentation I did in Shanghai University and Shanghai Justice Bureau a few years ago, which will, I hope, prove this point clearly. One of my PhD students was looking at two government regulators, our competition regulator, that is the Australian Consumer and Competition Commission, and our corporate regulator, the Australian Securities and Investment Commission, usually known as the ACCC and ASIC. And they use a device called enforceable undertakings, or EU. Now, these are legal documents under the legislation. They are court enforceable, but they do not have an admission of guilt. So if you've broken the law in these documents, you do not say so. However, you agree with the regulator that something has gone wrong. You agree to a media press release to be on the public record that you as a corporation, you as an entity have entered into such an agreement with the regulator, and that you will usually do X, Y, Z. It may be a compliance program, it may be training, it may be an ex gratia payment to consumers. It could be a $200,000, so about £100,000 payment to a charity or to an education fund, depending obviously on what the matter is. And EUs have had a mix of success. The benefit, of course, is they're relatively quick. They avoid going in front of a judge or in a jury for a criminal case. And they are reported, and the numbers of these varied from year to year. Now, recently we had a Royal Commission which felt that EUs, that is enforceable undertakings, have been overused and that they should in fact have more litigation. Regulators should take parties to court and have judges determine outcomes. Well, of course, COVID has subsequently hit and court proceedings have changed greatly because of online requirements, as in the UK and many other jurisdictions. Judges have had to get used to this technology. And one of the consequences of that is there's been less litigation. And in fact, there's been a greater use of enforceable undertakings. Now, that's all within the Australian context. But in other jurisdictions, particularly the US, a similar device is used either as a plea bargain, a negotiated settlement, or things called consent orders. Now, these can all be found, but understanding the similarities, the nuances, the distinctions, and what works and what doesn't work makes it, I hope, interesting. The other example I'd like to give you is more the power of other languages. I was doing a master's program in China for a particular group of highly educated students in Shanghai. And I was talking about Australian corporate law and its enforcement. Now, just like the UK, we have civil law, usually suing for damages or injunctions. And of course, we have criminal law where there's been particular poor behavior and enforcement both in jail and or huge fines. However, Australia in the mid-90s introduced a concept called civil penalties. Now, if you think about the language there, it's a hybrid. It's a civil action, meaning it is brought in front of a single judge, but it does have a penalty. That penalty is $220,000, approximately just over £100,000 sterling, and or a 5-year ban on a director from being able to be a director, chair, or CEO of a company, to be an executive, and other consequences from the civil action, but all determined not in a criminal court. And in Chinese, there is no word for civil penalty. I, in fact, had 2 translators, as well as obviously both in written and in spoken language in Mandarin. And my class, who included some Chinese judges, started arguing about the meaning of civil penalty. And it took a long time when there is not a word in a language to describe a particular conceptual framework. They would easily understand civil law, they would understand criminal law, but this civil penalty was a bridge too far. And why it's so important that is in the area of director's duties, which I do a lot on. In fact, of course, civil penalties are the #1 remedy. So getting them to understand was pretty important. We got there in the end, but for me, it's a good illustration, I hope, of the power of language. All right, we're coming to my last slide or so, and then I'm certainly very happy to answer any questions if anybody has. So in conclusion, obviously, it's great to know one particular law very, very well. So in my case, it's the Corporations Act 2001, Commonwealth, because it's a federal law under the Constitution. And yes, there are 1,488 numbered sections in the Corps Act. It's a huge act of Parliament. And in fact, it covers insolvency, securities markets, as well as traditional company law. But very quickly, it was obvious that the Australian Corporations Act actually took elements of its law from EU law, from UK law, a little bit from the US, a little bit from New Zealand. It had some influence. Hong Kong had had some influences over time. So I started to find it more interesting to look at the Australian provisions and how the Australian courts deal with these particular provisions, and then look at other jurisdictions and start to see how they operate in a different market in a different way. So that was one of the aspects. I just, in a personal level, just found it so much more interesting and more expansive in that sense. Then I guess there's also just now, in the last 20 years, a much greater awareness of the legal world. As I mentioned, the technology and databases and primary sources means it is actually now easier to look at different jurisdictions and understand and compare and contrast. And of course, the power of social media, something happens in any jurisdiction in the world, how quickly that information is passed around the world. So sources of information of change certainly come through my Twitter feed, my LinkedIn profile, even through Instagram. Things will just happen, and it's so much easier to then chase it up, get the source, and work from it. But one of the aspects I think that we do miss out on, certainly in Australia, may be different in the UK, of course, that English language does dominate. Now, within the common law world, that does make sense. But there are many other major languages. And here in my law school at UNE, a third of my academics come from other jurisdictions where English is not their first language. And they bring a richness, and they still publish, obviously, in English journals, both in Australia, in the UK, and in the US. But they also often publish in their own language. I have a colleague currently in Florence and Milan who publishes fluently in Brazilian, Italian, and French, as well as English. Obviously, I have some Chinese colleagues who publish in Mandarin, and on it goes on. And I sometimes find that not having all those other linguistic skills, those other languages could have a whole depth of jurisprudence, which is sort of being missed out on even in the world of corporate law, let alone other ones. And in fact, if you ever want to look at a really interesting case that deals with this issue, there's a decision called Renault, as in the car manufacturer, against Zhang, Z-H-A-N-G, which is 2002 High Court of Australia case number 10. Again, if you Google it, you'll find it, where the civil code of negligence under French law. So Mr. Zhang was a Chinese national, lived in Australia, was on a French island and was driving a French motor vehicle which rolled and gave rise to a negligence case. The question was, where should the case be tried? And of course, Renault wanted it tried in France under French law, and the gentleman who suffered the injuries wanted it tried in Australia under Australian common law tort of negligence. You can see the tussle to the conflicts of law and choice of law that comes into play. You'd be interested to know the decision was actually the case should be run actually in Australia, that's where the jurisdiction where the harm happened under ordinary tort principles. But it's a great example of that conflict of language and legal systems, and it's a great illustration. Hopefully, I've been able to shine a light on why I believe comparative legal scholarship is of great value and great interest, and why I will continue to working in that space. And the next slide simply gives some an opportunities for questions, and also gives you my direct email address. And if you want to connect through Twitter or LinkedIn or my Chinese handle at WeChat, you're most welcome to do so. But Stuart and Steve, that's really my primary presentation. I hope that covered the things you were expecting, and I'm very happy to do my best to answer any questions the delegates may have.
Well, thank you very much, Michael. That was most valuable. I'll maybe stop sharing the screen so we pop up and the picture. I know we have a question from Rona here.
Can you hear me?
Can you hear Rona there, Michael?
Yes, I can. Thank you.
Thank you for very interesting talk, Michael. I think lots of us have been thinking a lot about governance in the last few years, especially when we had to put up with, tolerate one way or another, President Trump. And we're thinking of the power of Facebook. Now, yesterday, I don't suppose you were able to attend the meeting yesterday, but yesterday we had a frankly terrifying and a brilliant presentation by Ben Stanford. And he put on the slide 5 current attacks on our democracy from our present government, which appears to have no respect whatsoever for the ideas of democracy, and is enacting very powerful legislation to stay in power forever, voter identification being only one of the 5 elements. And so my question to you is, what do you think, how can democracy survive with no effective governance over Facebook, which frankly agrees that their algorithms favor hate speech because that is what draws people, and it's a commercial model. So how do we survive? How does democracy survive in the age of Facebook?
Thank you. That is a fantastic question, and to be honest, I could give it a very long answer, and I'll do my best to give it a short, sharp answer. First of all, Facebook as an entity is being challenged on a jurisdiction to jurisdiction basis, and what I mean by that is, you probably know, since 2000, I've flown into China over 25 times. And when I'm in Hong Kong, I can easily access my Facebook and my Twitter account. As soon as I land in China, it is blocked. There is no Facebook, and you switch to Weibo and WeChat. And you know the government is monitoring everything that is said and done. But France has had some successes against Facebook. Australia, of course, took on Facebook in terms of news coverage and the financial requirements of the originators of those materials. And Facebook originally said, no, we're not going to pay money. And in fact, they did fold after Google accepted that they should pay funds to the major news providers. In the US, of course, Facebook has a big battle going on. There's a big US Congress inquiry going on, etc. So I think it is a point in time answer. I think the Cambridge Analytics started to teach people of the difficulties of those algorithms and the monopolistic type cases. But I think the freedom of speech, I don't know if you've just heard the announcement, I think it was yesterday, YouTube has now in the US changed all anti-vaccination videos to be blocked. And I don't just mean COVID, I'm talking about polio, all the standard vaccines. There are so many anti-vaxxers YouTube has made a decision that if it is a legally proven vaccine by our relative health authorities, an anti-vax video is just prohibited, and that they're using their algorithms to stop that. That only came into effect yesterday. So I think those big monopolistic, powerful technology companies will be brought to heel, but it will take time. And I think there will be a gap. And of course, the law, I'm talking now legislation, tends to take 5 to 10 years to actually bring it up to, the coherence it may need. So there's always a delay and parties do it. So that's not a full answer, but within the timeframes, I hope that gives some response to that issue. And I think there are some really interesting aspects. And there is being work done, of course, out of Oxford University on this particular area.
Thank you, Michael. I see we have a question from Alex.
Yeah, that's correct. Thank you very much, Stuart. And thank you very much, Professor Adams, for that talk. Very interesting. Yeah, I'm actually, I'm a member of staff at the law school, and I'm presently doing my PhD, which has a comparative element. And I've just got a couple of questions on comparative law generally. Firstly, what's your opinion on comparing common law systems with civil law systems? Do you think there's any value in doing that? Secondly, relatedly to that, which taxonomy do you think is the best maybe for classifying systems? You had the big map of the world there with all the different systems blocked out on it in different colours. And I was just interested as to what your thoughts on that were. And also, if I could trouble you for a third question, how important is this idea of legal culture, do you think, to comparisons? Because I know there are some people out there, some academics that will say, you haven't really got a right to compare, let's say, the law of Austria with the law of the UK, unless, for example, you've practiced law in Austria for 30 years and become proficient at the flugelhorn and not absolutely immersed yourself in Austrian culture. So what's your overall take on those points, if I may trouble you?
Yeah, thank you, Alex. I appreciate the question. You may need to remind me, because I wasn't making a note of the three questions.
Yeah, sure.
To answer all three when we get there. I'll try and answer them in order. And first of all, congratulations also doing your PhD. That's a great journey to do. And I look forward to hopefully meeting you as when I get back to Coventry at some point. So, right. So your first question was around, is it worthwhile? I mentioned that case Renault and Zhang particularly, because when you do a deal, I always, I used to teach first-year law students, although corporate law was my main area, and I used to do generalization. I'm sure you've heard it. So the civil code system in Europe is like the Volkswagen. It's the people's court, it's investigative, but the common law is the real dice. That's the detailed analysis, etc. Now, if we're not too cynical, the common law system works if you have money. It does not tend to work if you're poor. And poor, of course, is in Australia, a court of first instance, the equivalent of the High Court in Australia, would cost you £100,000 or £200,000 to run a case. So in other words, unless you're rich or you have good insurance, you're not going to bring a case. Whereas in Germany or other similar places. However, that case, Renault and Zhang, was looking at the tort of negligence. And if you look at both in the original French and the standard official EU translation of the clauses, the articles dealing with negligence, you're pretty the same as Lord Atkins, Donoghue and Stevenson, right? It doesn't express it as the neighbour test, but it does talk about a duty of care, and there is a concept of remoteness of damage. So I think sometimes we overplay the distinction, but I think there's still value. But you're absolutely right. You've got to be careful of the nuance. And of course, that's where I would suggest often a co-author can be very valuable. When I did work in finance, a lot of my most famous work is in the area of insider trading and market manipulation. And I worked with a very close colleague, Professor Mark Freeman, who was a professor of finance and economics. And so he taught me the language of finance and economics, and I taught him the language of law so that we could get to a common page. And it also, if I made an outlandish statement, he would pull me back and vice versa. So the answer is, I think it's valuable, but understand our limitation, particularly if it's multilingual, because we all know the nuance. What is it? There are 34 different ways to describe the word love. You know, it's that sort of idea. Which meaning do we actually attribute it to? So I think that's your first question. Your second question was?
Is on the taxonomy of classifying these systems. So how would you approach that? Or do you use any one particular school of thought on that?
Yeah, I do. Can I, as soon as I finish, I'll pop it in the chat button so you can actually see the reference. There's a great book which you can get in the UK by Dr. Terry Hutchinson from QUT, Queensland University of Technology. Her research methodology book is used by virtually all PhD students in law in Australia. But the second half of the book goes through different legal systems and their primary resources, including China, Europe, etc. And it's an amazing resource. It's in its 4th edition, and it actually gives you some great taxonomies, both from a methodological approach as well as resources. So I'm happy to pop that reference in the chat box. You may find it useful, but as I said, I'm positive it is sold in the UK.
Please do. That sounds extremely helpful.
I actually give one to every PhD student. So we have here at UNE about 20 PhD students. At Western Sydney, I had about 30 for the school, and at UTS we had about 50. And this book was the standard thing we gave them to help them with their methodology and research methodology. So your third question?
Third question was on, well, thank you very much for that. That's extremely valuable, and I would appreciate that if you could put the reference in the chat. That'd be amazing. But yeah, the third question was, how important is legal culture? Because, you know, some academics say, you know, you haven't got a right to comment on, for example, the law of Switzerland or Australia or wherever, unless you've absolutely steeped yourself in the legal culture and, you know it inside out. You can't really then, you know, compare Austria or Switzerland with the UK unless you have a deep understanding of the other culture. But I mean, it's clearly not that practical to have that much of a very deep understanding of other systems, particularly if you're comparing a number of different systems. There's no way you can really ever have such a deep understanding as you would your own system. So what is your overall take on that?
That's a great question. I think it can, I'm going to answer in a funny way, but It can be used as a shield and a sword. And what I mean by that is, if you want to put up an argument to say, leave us alone, it's too sophisticated, I think that's ridiculous. I'm going to be controversial here. It's a bit like, oh, you can't look at Wikipedia. Why not? Wikipedia could give you an overview of something and other eyes are looking at it. You're not going to use it as an authority in a court of law. You're not going to put it in your PhD thesis. But if you want to get a quick overview to know the right questions to ask, you'll be amazed how quick and easy that is. So I'm using that as an analogy. The cultural piece is the I've enjoyed engaging with international scholars and actually discussing what I said earlier was the nuance. So the example I gave was enforceable undertaking. My student, who's now an associate professor, by the way, at University of New South Wales, her name is Marina Nam. She did her degree in French in Lebanon before she did her master's in the US, and then she did a PhD with me in Australia. She speaks fluent French, Arabic, and English. So her ability to compare and contrast linguistically was far superior to mine. But of course, what I understood was the legal concepts and the constructs behind it. But we had some very engaging conversations. So again, Alex, can I suggest, not for your PhD, but for your publication, co-authoring is a great way to solve some of those issues. But it can get you in trouble with reviewers. When you send out articles for review, blind review, if you get somebody who says, I'm the only one who knows that stuff, that's where the problem is. Practically can occur. All right. So I have actually just Googled that book, and I will pop an actual link into, obviously it'll be an Australian reference, but you'll be able to get it from there through your local bookshop. So I'll pop that into the chat for your benefit. Okay, you should, it's from eBay. There you go. It's an eBay reference to buy the book. So and I'll give the author's name. So Alex, I hope that answers the question.
And I believe we're monetizing at the conference now. We have a question from Mahmoud.
Yes, Mahmoud.
Hello. Yeah, thank you, Professor Adams. I think your presentation was really, really good.
Thank you.
Now, just like Alex, I teach in the law school, and my PhD is specifically on comparing and trying to reconcile Islamic law and international human rights. And I would like to know what your take on this in terms of practicality and significance.
Yeah, thank you. Well, you saw one of my articles was with my PhD student from Iran, and we had many discussions on these issues. And I am certainly, can I just say, not an expert at all on Islamic law, etc. But what I have learned from my colleagues, I've actually done quite a lot of work in Bangladesh. And the Bangladesh court system, because English is the official language that is used by politicians and the courts. And there I quickly found, of course, and I believe, and if this is wrong, please correct me, but certain areas of law, such as commercial law, are often done in English with English principles behind it. By English, of course, I mean UK based. Whereas private law relating to families, division of estates, marriage, etc., well and truly come within Islamic culture and history and laws and provisions, and as such are dealt with by different judges within their court system. So I think it depends where we're comparing and what we're comparing and how we're comparing can play a role. But if I was certainly doing some work in that space, I would work with a colleague that understands Islam, understands those legal systems, because it is, you know, the civil code system is hard to get our head around, but a lot of it is translated into English officially. So that comparison is slightly easier. In the Islamic aspect, there is less, my understanding is there's less translation, and it's probably not quite as accurate. And I said that's particularly my experience has been through Bangladesh and the Bangladesh courts. But is that a fair summation to say the distinction between and the difficulties of that comparison?
Yes, I do agree. On the point of commercial law, I think that's why in the Middle East, if they want somebody who is commercially experts, they would look for Western minds. But when it comes to family law and when it comes to other private matters, they would refer to Sharia law instead. So
yes,
yeah, thank you so much.
And I had a PhD student that looked at usury laws in Indonesia, and that was a very good example. So the banking finance aspect, of course, was under, you know, more traditional commercial law principles, but the usury aspect of the banks in Indonesia that look to Malaysia to look at different ways of allowing loans, but without breaching the interest provisions, was for me a very good example of that comparison. It sounds like you're on a very similar track of mind.
Yeah, thank you so much. Thank you.
Thank you for your question.
Well, thank you both. And actually, I think, Michael, that reflects a link to one of your very concluding points, which was the value of being able to read in other languages as well. Because, you know, I know this you know, I work principally in taxation law and European Union law, and the working language of the OECD is French, and the working language of the Court of Justice is French. And I have over the years found some considerable value in being able to actually understand some of being able to read in French and being able to read, for example, amendments to the OECD Model Convention in French, and get a better understanding of what they were trying to achieve with this than subsequent translations. And there have been certain judgments of the Court of Justice where, again, there's been a similar advantage to that. So, and I think that certainly reflects what both of you were saying. I'm going to have to draw things to a close here, except to exercise a degree of chair's privilege to ask a final question. And it's a question I'm asking really on behalf of our LLM students, many of whom aren't here because they have a public international law class today. As a dissertation supervisor on the LLM, I think the most common form of LLM dissertation, the most common method employed by our dissertation students is some sort of comparative study. We get that, I think all of my colleagues in the room would agree, comparative LLM dissertations are by far and away the most common. But the most common defect I often see with these is I get a wonderful explanation of the value of comparative legal research, but the one step they so often fail to take is explaining why they have chosen to compare the jurisdictions that they've chosen. Now, usually it's, oh, because I'm studying in England and I'm from somewhere else, and so I'll compare the two of those. Now, that doesn't really stand up to scrutiny. So I wonder if, Michael, you could perhaps provide our LLMs with some tips as to how, when you're undertaking some comparative legal research, how you actually go about selecting jurisdictions for comparison.
Stu, that is a great question, and I think you're right. That would be my own experience, would be very common in dissertations that they miss that point. They're very good at describing, but the analysis and the rationale is not always clear. Certainly from a PhD student perspective, one of the early things we do is we have within the first year of a PhD program, we have something called a confirmation of candidature. So somebody has to put up basically what their thesis is and what their methodology is and why they've chosen it, etc. And we often, where there's comparisons, ask that exact question: why did you choose this jurisdiction? And often they haven't really thought about it. Sometimes it can be lazy, such as the materials were easily available, or sometimes there has been some serious thinking behind it. So my first question would be, you should certainly, a bit like a literature review, you should certainly be checking and having a clear rationale why you compare one country with another country. And of course, there can be two major reasons. One, that you could be looking for similarity, so you can then look at, particularly with this legislation, have the courts applied the same principles in the same way. But sometimes it's really fun to look at a very different jurisdiction to see how they've solved or attempted to solve the same mischief. And that to me is much more interesting. So I often will push and say. The other is a bit of triangulation. In other words, rather than just doing one country with another country, why not look across 3 different countries? And again, one of my PhD students did a great thesis on remuneration of directors and their profitability. And she looked across 3 major jurisdictions, one of them being Japan. Now, the materials in Japanese were much harder to get. Obviously, the language issues were difficult with the US and Australia, with the other comparators. But we made sure we wrote in the chapter a clear explanation why those countries have been chosen, what the cultural differences were in respect of their construction of boards and remuneration, and the sort of the average earnings and what that may mean. And that data, I have to say, made for a very interesting PhD.
Excellent, excellent. Well, I'm sure our LLMs will find that of great value. So thank you very much, Michael.
Pleasure.
So to wrap things up there, thank you so very much to Professor Michael Adams for joining us from Australia. It's now getting into the evening there, and a Friday evening as well. So
it is, and I'm looking forward to going out to dinner.
I was going to say, I hope a beer is in order for you now.
I think a beer is very likely.
Excellent stuff, excellent stuff. And also, I hope, I understand you'll be back and you're planning to return to the UK next year, so hopefully we will see you then. But if not, I hope, given our new technological revolution, we might perhaps see you a bit more often, even if you're virtually here at Coventry Law School as well.
Well, that would be an absolute pleasure. And I seriously was very pleased indeed, and very honoured to be asked to speak as a keynote at this conference. And what a celebration, 25 years of a journal, and under Steve's control and encouragement, watching it grow and develop and gain in sophistication. And said, when I saw that it's in Scopus and other major databases, that's a great testament to the quality of those papers over time.
Well, thank you very much, Michael.